Morari. He's present, Judge, on the Zoom screen. This is
Okay.
a request for temporary, really, we're trying to change custody under a temporary order, Your Honor, as to the child, Esther Emily Morari, Judge. She's 13 years of age.
And Your Honor, the petitioner is a non-resident. I think he lives in, is it Oregon?
That's correct.
And so he wants to take the child to Oregon, and she lives along with her mother, who's here with me, and her four other children at home. She's the oldest of 5, and Ms. Luna is employed, but she takes care of her children along with you. Have the help of your mother.
Yeah. Well, I try to do everything by myself.
Very well. So we're ready, Your Honor. We don't believe that she needs to be moved away from her brothers and sisters to Oregon.
If I may, Judge, this is an allegation. This is the only child that my client has with the respondent. The other children that they're referring to is from a different relationship. The allegation, Your Honor, that is in the petition is that the child, well, basically the child tried to commit suicide, Your Honor, this year. My client gets a phone call from CPS to come down. He comes down. The child basically harmed herself. And the allegation basically is the reason because of the relationship the child has with the mother. So we're concerned about the emotional state of the child. Under the Texas Family Code, a court can change custody under temporary orders if the court makes a finding, if there's a finding of significant emotional harm to the child. We are asking the court also to interview the child. I don't know what the court's procedure right now is interviewing a child in chambers, but we believe this may be necessary for the child to be interviewed in chambers or the court to be guarded.
Okay.
We can arrange that, Your Honor, to have the child brought over. She's attending school, virtual, and I didn't tell my client to bring her because she starts school this morning, right? Yeah. And Your Honor, in response to the allegation is, if you can hear me, Judge.
Yes.
The teenage girl, the preteen girl, was abusing her cell phone, and my client, in discipline of that child, took the phone away from her, and this is what she began to do to hurt herself. But my client, very caring mother, she's now in a program with Tropical, and she's attending classes, and she's been doing that for what, 2 weeks now?
She's been doing that for a month.
A month already. So hopefully the petitioner can be satisfied with the fact that she has submitted her for treatment with Tropical here in the valley where she lives.
Judge, my client's not satisfied. He basically gets a phone call from CPS. Then he gets a phone call from the maternal side of the family about the concerns for this child, Judge. Yes, my client lives in Oregon, Your Honor, but this child is reaching out to him basically for help, and she wants to live with her father. We think in order to prevent something serious happening to this child while still in the mother's possession, Judge, I'd rather play it safe. Let's play it safe and have the child with dad right now, because if the child's in any harm or creates any harm to herself further, it's going to be detrimental to all involved in this case. If we could have stopped or we could have prevent this child, it's serious. We have a child who harmed herself.
She's doing well now.
She just got enrolled in, what is it again? Tropical?
The Tropical counseling, Your Honor, and to remove her from, and you know, the father is not that much of a caring father. He hasn't provided much support at all until just recently, just like this week. So for months he has gone without paying any kind of support. And Makana isn't insisting on that. I want him to worry about, she's got a job. She's got a professional job. She's got other 4 children, which she's caring for.
Why don't we set this matter for status down the line and see what's going on? Let's see what the results are from Tropical and any other counseling, and then we'll check it out.
Judge, my client's also concerned about the child has mentioned that mom basically uses drugs. So I'm asking for if both sides can do a hair test. Basically, let's both sides do a hair follicle test, Judge, because if that's concerned, I'd rather see what the situation is. I'd rather have each side go to Pro Lab and do a hair follicle test within 48 hours. My client can do a hair follicle test in Oregon, and I'm asking for the mother to do a hair follicle test.
We agree. That's a good idea, Your Honor. Good
All right.
idea, yes.
Let's do it. Let's do it. Let's see what the results are from tropical and come back on the status hearing.
Let me ask
You
her,
want-
Your Honor, under oath, how long will this program go with Tropical?
Until she needs it, until she no longer
Until
needs
she's
it.
no longer needed. So what, another 2 or 3 weeks maybe?
I don't know, until she feels like she doesn't need anyone. Right now, we just need to get her the help, and her father's not doing that. He just wants to take her away, not to get her help.
Is she well now? Has she,
Well, since I took away her phone, she's.
Mr. Peña, the court reporter cannot hear your client. She needs to get closer to the mic.
all right.
Yeah.
Oh, is she doing well now? Was my
Yeah.
question. She's
Yeah,
doing
that's
well.
why I wanted a status hearing, like later on. Let's find out what the results are with that tropical setting, and then come back with the results on the drug testing also, or follicle, and let's check it out.
But
Judge,
Your Honor,
I know my client wants to say something, Judge. Can I ask my client if he understands what concern he has?
Yes, sir.
Needs to be sworn in.
Yes, Your Honor. I just wanted to also say, I was hearing what,
Everybody, stop. Can you raise your right hand? I need you, if you're going to say something, you need to be sworn in, okay?
Okay, you swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
yes.
All right, put your hand down, go ahead.
All right. I wanted to also point out, I'm not too sure, but what's called I had, my mom was talking to my daughter as well. Now, if I didn't care about going down there to Texas, I would have just stayed up here. But I decided to go over there because it's my daughter. I've always loved her. I've never, and then on top of that, I'm paying child support, showing that I care. Because if I really didn't care, I would have just disappeared on her a long time ago. But I love my daughter and I care for her. But recently, what also happened, I understand CPS supposedly from what Jasmine had told me when I was down there in Texas that I was told that she was that the CPS order was canceled from the suicidal because I don't know why, but at the same time, she is from what I was hearing that she was getting treatment for tropical, but when she was texting my mom, she was saying that she was thinking about doing it again, doing suicide thoughts because due to the fact that she was staying at her mom's at Jasmine's mom's place, and they were arguing for something that they're going through, and they were
Okay.
taking it out on my daughter.
All right.
Okay. Yes, Mr. Peña?
if his mom is present, we'd like to ask her some questions.
Yeah,
Be sworn in.
Talking about what her mom said.
okay, ask questions, yeah, go ahead.
She hasn't been sworn in.
Is your mom there?
No, she's not, but I did send photos to my lawyer.
Is she available to testify?
She's not
Look.
available right now.
Look, let's keep the status quo right now and let's continue with treatments and do the testing, and let's come back for another setting. And if necessary, bring in your witnesses, okay?
Very good.
Yes.
Moms, grandmothers, whatever, okay?
What date, Your Honor, please? 2 or 3 weeks? A month?
Well,
A new order sitting here.
give me a new order setting hearing and we'll come back in about a month or so.
All right.
Submit a new order setting hearing date and we'll get you a date.
Judge,
Very
if Bishop Peña's office has the records for Tropical, if I can't get those records, if they have the records, can they provide
I'll-
the records?
Everything I have, Mr. Hinojosa, I would share with you, every bit of it.
Every bit, okay,
And we will do the laboratory.
Okay.
also. Thank you,
and
Your
let's
Honor.
find out. Let's find out where we are and then we'll take from there, okay?
Thank you.
Thank you all very much. You all may be excused.
Thank you.
Log
Thank
out.
you.
Thank you, Judge.
Thank you. Okay, you can see it. Oh, friendly suit, okay. Here, okay.
I'm gonna sit in the front.
All right, let me see here. Let's see, we got a friendly suit. Let's see who's gonna be testifying here. We're here on CL 186337D, Ruby Sens versus Kids College Learning Center, LLC. Mr. Pruneda, I see you there. Good morning. Can you see me? Can you hear me?
I can see you, Judge. Yes, sir.
Oh, wow, great. And now we have Ms. Ramirez. Can you hear me?
Yes, Judge, I can hear you.
All right, very good. Mr. Rorik, there you are.
Morning, Your Honor.
Can you hear me? Of course you can,
Okay.
right? All right. Thank you all so much for showing up. Who's going to be testifying? It's gonna be Ruby Sense?
Yes, Judge.
Judge, David, is your client not going to be present?
My client? No,
Yeah. No,
no. Is Miss Sens?
she's there. I don't see her face, but she's
Okay,
logged
right.
in.
Yeah, no.
Okay.
Did you have testimony you wanted to get from my client?
No.
No. Okay. Yeah, I didn't think.
Okay, Miss, let's see, Ruby Sense, can you hear me?
Yes, Judge, I'm here.
There you are. We just can't, there you are. Okay, now we can hear you, we
Hi.
can see you. Good morning.
Hi, good morning.
All right, so this is a friendly suit, right?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Okay. All right, please raise your right hand, ma'am. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
You may put your hand down. Who's gonna get it started here?
I guess that'll be me, Your Honor.
Mr. Rorick? Go ahead, sir.
Good morning, Ms. Sens. My name is David Rohrig, and I am the attorney that was retained by the insurance company for Kids College. Do you understand that?
Yes, sir.
You and I have never met before, correct?
No.
So you've had a chance to meet with the guardian ad litem, Mr. Ramirez, who the court appointed on behalf of Colton, correct?
I have.
And do you feel you've had sufficient time to consult with her and discuss kind of the underlying incident and Colton's condition with her?
Yes.
And after consulting with her, did you come to the conclusion that the terms of the settlement are in the best interest of Colton?
Yes.
Did I word that kind of poorly?
No,
you're
it's
doing
fine.
You're doing fine.
I just want to make sure that you have had a chance to discuss this case with Mr. Pruneda, the lawyer that you hired for yourself, and that you've also had plenty of time to talk about this with Mr. Ramirez. And you guys are all in agreement that this settlement is in your child's best interest.
I have.
Okay. And you understand that by coming here today and asking the court to approve this settlement, you're giving up any right to assert any other claims or causes of action against Kids College and any of its employees, correct?
Correct.
Okay. And you understand that you're agreeing to the language in the settlement that states that the underlying incident that allegedly resulted in injuries to your son was a fight between two children, between your child and another child, correct?
Based on the evidence that was presented for this case, yes.
Okay. Do you have some other cause of injury that you believe is true and that this is not the true cause of the injury to your child?
I was not present on said day, so I'm not witness to exactly what may have occurred, but based on the evidence that's been presented, that is what the allegations are. It was a fight, apparently, so that is what I've agreed to.
Okay. You've agreed that that's the truth as best as you know it.
Correct.
Okay. And it's not your intention to come into another court and offer testimony to the contrary?
No, if I don't need to, I will not, no.
I'm not sure what you would mean by that. What do you mean if you don't need to?
Well, based on the settlement agreement, the claims are being released. So if the claims are being released, then there is no other thing that would transpire aside from what is being agreed to here.
Okay. I ordered a set of the pediatric records from Colton's pediatrician, and aside from sort of a dictated letter that was not dated and didn't seem to be kept in the normal course of business, there were no notes in the pediatrician's file regarding you bringing Colton into him and saying, you know, he got injured at school. Can you take a look at this injury? Is that right?
To my knowledge, there was not, but I did take him.
Okay. And as we sit here today, has Colton fully recovered from any injury that he might have received on September 8th, 2018?
Physically, yes.
Okay. Is there some manner in which he has not recovered?
I believe that he still has some remembrance of the occurrence where he gets a little scared maybe sometimes or startled where he starts at a new school. So I think mentally it's affected him still. It doesn't always, I mean, I think for the most part, he's doing really good. It's just sometimes there might be like a trigger for him, but aside from the psychological form, again, physically, he's okay. And overall, he's okay. I mean, I think that I've done my best as, his mother to just kind of put that behind us now. I mean, it's already been 2 years.
Okay, you're saying that from this altercation that he got into with another young boy, he still might have some issues getting scared or things like that.
Right.
Okay. Okay, and you're agreeing that this issue that brought us here today is a civil matter, that, there were some misunderstandings, but in essence, it's a civil matter and you are fully and finally resolving it today.
Yes, sir.
Thank you for your time, ma'am. Best of luck to you.
All right,
Thank
thank you, sir. Mr. Pruneda?
Ms. Sens, I have just a follow-up question. You've had an opportunity to take all the time you need to review the settlement documents, correct?
I have, yes.
Okay, and you've also made suggested changes which have been made, and we're waiting for several of the other parties to execute the agreement. You understand that, right?
I do.
Okay, and has anyone forced you, coerced you, or put any pressure on you to sign any of those documents that have been presented to you?
No.
Okay, I have no further questions, Your Honor.
All right, thank you, sir. Ms. Ramirez?
Thank you, Judge. Ms. Sens, you and I, we've met a couple times in reference to your son's case. Is that correct?
Yes, ma'am.
And we have gone over the settlement agreement, and we together with you and your son, we came to the realization that this is the best interest to your, this is for the best interest of your child. Is that correct?
Yes.
Now, Ms. Sens, were you satisfied with the services of the ad litem?
Yes.
Now, at any time, Ms. Sens, did myself or any other attorneys put any pressure on you in any way to get you to come to this agreement?
No.
Judge, at this time, as the ad litem of the case, Judge, we have reviewed all of the documents. We also reviewed the settlement agreement, and we believe this is going to be a little different, which is not going to get registered. I'm sorry, it's not going to get registered into the county's account. It's actually going to go into a separate account, which I had talked to both the attorneys, so we can put it on the record, just so that way we can be clear as to how and when he will be receiving his money. And aside from that, Judge, I have no further questions, and I do believe that this agreement is in the best interest of the child in this case.
All right, thank you very much. Court will take judicial notice of the entire file in cause number CL 18-6337D in the case of Ruby Sens as next friend of a child versus Kids College Learning Center, LLC. Court will hereby approve the minors settlement and will await a judgment for signature. Everybody okay? Anybody, any more questions?
Michael, I was just curious what specific changes Ms. Sens requested. I want to make sure those are things that I've seen and specifically looked at.
Yes, nothing has been modified in the last few days. It's been presented to you already.
Okay, great. Thanks, Mike.
All right, thank you.
Amidas and I have an agreement as to
Okay.
liability fees, and I've got that inserted in the judgment that's being circulated for signature and will be presented to the court hopefully later this afternoon.
All right, thank you all very much. You all may be excused. Have a great day, guys.
Thank you for your
Thank you.
time.
Yep, thank you all. Bye-bye.